Picture this: trillions of dollars in assets, the hopes of millions of investors, and the very blueprint for the future of money hanging in the balance as two titans clash, not in a backroom negotiation, but in the glaring spotlight of a federal courtroom. This isn't a thriller from your bookshelf. This is the real, high-stakes showdown between Ripple Labs and the United States Securities and Exchange Commission, a legal saga that could forever alter the fate of digital assets, not just in America, but around the globe. Why is this case so monumental? Why are crypto enthusiasts, Wall Street veterans, and even government regulators watching every court filing with bated breath? Let's unravel the full story and dive into the intricate web of consequences, innovations, and possibilities surrounding the Ripple SEC battle. To truly understand the magnitude of what's unfolding today, we need to rewind the tape to December of 2020. Back then, the world was still reeling from a global pandemic, but the crypto market was on the rise. Enter the SEC with a bombshell announcement. Ripple, they alleged, had conducted an unregistered securities offering through its sale of XRP tokens, violating the iconic Securities Act of 1933, specifically Section 5. Almost overnight, confidence in XRP evaporated. The price of XRP plummeted by nearly 70% in the span of just 30 days, erasing tens of billions of dollars in market capitalization and sending shockwaves through an industry already wary of regulatory scrutiny. For context, this was one of the most dramatic price collapses in the history of digital assets, a reminder of just how much regulatory risk can move markets. But the SEC's case wasn't just about numbers on a screen. At its heart was a fundamental debate. Is XRP a security, like a stock or bond, which would require registration and strict oversight? Or is it a digital currency, a technological tool for moving money across borders, and thus outside the SEC's jurisdiction? The SEC pointed to the Howey test, a legal standard dating back to 1946, arguing that XRP was an investment contract, since Ripple had promoted its value and institutional buyers might expect profits from Ripple's efforts. Ripple, for its part, stood firm. XRP, they argued, was designed to be a bridge currency, a neutral asset enabling fast, cheap, and secure cross-border payments. The stakes could not be higher. If the SEC prevailed, it could set a precedent impacting thousands of crypto projects, potentially halting innovation and driving companies offshore. If Ripple won, it could usher in a new era of legitimacy for digital assets in the United States. This legal tug-of-war has carried on for years, marked by motion after motion, hearing after hearing. The case has drawn in a veritable who's who of financial experts, legal scholars, and industry leaders. Judge Annalisa Torres, presiding over the case, has become something of a celebrity in the crypto world. In July of 2023, she issued a landmark ruling. While XRP itself is not a security just by existing, some of Ripple's institutional sales could indeed be classified as securities transactions. This nuanced partial victory was enough to send XRP's price surging, with daily trading volumes jumping by more than a third in the weeks that followed. For many, it was the first glimmer of hope that the courts might finally bring clarity to the murky waters of crypto regulation. Yet, legal clouds lingered. The SEC, unsatisfied with the partial win, continued to pursue remedies and reserved its right to appeal. Ripple, meanwhile, did not rest on its laurels. Instead, it doubled down on innovation and global expansion, forging new partnerships and launching bold initiatives. In April of 2025, Ripple teamed up with Afrique, a fintech leader in Africa, to overhaul cross-border payments. The goal? Make remittances faster, cheaper, and more accessible for millions who rely on money sent from abroad. Standard Chartered Bank, one of the world's most influential financial institutions, adopted Ripple's payment solutions for select corridors in early 2025, unlocking a new era of instant, low-cost international transactions. Even SBI Remit in Japan integrated Ripple's MoneyTap app by May of 2025, letting users experience near real-time money transfers at a fraction of traditional costs. Behind the scenes, Ripple's financials reflected its momentum. For the fiscal year ending 2024, Ripple reported a net income of $345 million, a 15% increase from the year prior. This wasn't just profit on paper, it was proof that blockchain-based payment systems were moving from hype to real-world adoption. And the world's largest asset manager, BlackRock, quietly added XRP to its short list of assets under consideration for a future exchange-traded fund in February of 2025. David Schwartz, Ripple's chief technology officer, summed up the company's approach. Our focus is on building real-world utility for XRP and blockchain technology, regardless of the SEC case outcome. Ripple also expanded its compliance infrastructure by acquiring Fortress Chain in March of 2025, signaling it was prepared to meet even the most rigorous regulatory standards head-on. But as Ripple expanded, the legal drama continued to simmer. Fast forward to June 16, 2025, the SEC filed a status report with the Second Circuit Court of Appeals, requesting that both parties' appeals be held in abeyance, a legal term for putting things on hold, while Judge Torres considered a revised joint settlement motion. This was not the first time both sides sought a pause. Just a month earlier, in May, Ripple and the SEC had submitted a joint motion seeking to resolve remaining issues about institutional XRP sales. Judge Torres, exercising careful scrutiny, rejected that initial proposal, stating that it lacked sufficient justification. Undeterred, both parties went back to the drawing board, filing a more detailed and robust second motion on June 12th. Now everything hinges on Judge Torres's next move. Will she approve the revised joint settlement motion and signal the beginning of the end for one of the most watched financial cases of the decade? Or will she find the new arguments lacking, sending the dispute back into the tangled web of appellate litigation? Attorney John Deaton, a widely respected observer of crypto law, estimates there is a 70% chance Judge Torres will approve the settlement, allowing the appeals court to formally remand the case and potentially bring closure. The SEC has promised to file another status report by August 15th, meaning the next 2 months could determine the entire trajectory of American crypto regulation. The tension is palpable across the industry. SEC Commissioner Kristen Johnson has stated, "The SEC must provide clearer guidelines for digital assets to foster innovation while protecting investors." These words echo a growing sentiment. The United States, once the world's leader in technological advancement, is now at risk of falling behind as other jurisdictions, such as Europe, Singapore, and the United Arab Emirates, roll out comprehensive digital asset frameworks. Legal uncertainty, many experts argue, remains the single biggest obstacle to unleashing the full potential of blockchain technology. If the court's decision breaks the deadlock, it could spur a wave of investment, product launches, and partnerships. If not, the shadow of doubt will persist, chilling innovation and pushing the next generation of fintech entrepreneurs to friendlier shores. Consider this. Ripple's ongoing efforts include piloting a central bank digital currency, CBDC platform in partnership with the Central Bank of Bhutan. This project aims to improve financial inclusion in a country where access to banking is limited by geography and infrastructure. Ripple's CBDC platform is also being eyed by other emerging economies as a blueprint for digitizing national currencies. In Latin America, MoneyGram has expanded its partnership with Ripple to include blockchain-based settlements for cross-border remittances, helping millions avoid excessive fees from traditional money transfer operators. XRP's utility is not theoretical. In the first quarter of 2025, the daily volume of XRP transactions rose by an astonishing 35% compared to the previous quarter, driven largely by institutional adoption and expanding use cases. For example, small businesses in Africa now use Ripple's rails to pay suppliers in Europe in seconds rather than days. In Japan, families are sending money to relatives abroad with unprecedented speed and transparency, thanks to the MoneyTap service. These are not just statistics. They represent real-world impact, showing that regulatory clarity can unlock life-changing innovation for ordinary people. But the looming question remains, what happens next? If Judge Torres approves the revised settlement motion, the effect could be seismic. It would represent the closest thing to regulatory clarity that the crypto industry in the United States has seen in years. Companies like Ripple and hundreds of other startups building on blockchain would have a green light to accelerate their partnerships with banks, payment providers, and fintech firms. Standard Chartered and MoneyGram, for instance, have both expanded their use of Ripple solutions this year, and cross-border payment volumes are surging. Such momentum could trigger a virtuous cycle, where institutional confidence begets more adoption, driving innovation and economic growth. A positive outcome could also inspire Congress to act. Some lawmakers, recognizing the limitations of the current patchwork approach, are pushing for new legislation tailored specifically to digital assets. Georgetown law professor Linda Zhang has warned, Congress must act, or we risk ceding leadership in digital finance to other regions. The lesson from recent history is clear. When America leads on regulation, it shapes global standards. When it hesitates, others fill the void. Look at how the European Union's markets in crypto assets regulation, MiCA, is already attracting startups and capital from around the world. Yet, a denial or further stalemate would plunge the case back into appellate litigation, potentially dragging on for years. Legal experts caution that a protracted fight could stifle innovation, deter venture funding, and force many of the brightest minds in crypto to relocate overseas. Jake Chervinsky, chief legal officer at Variant Fund, observes, even with a settlement, the SEC's enforcement-first approach creates uncertainty for crypto businesses. This uncertainty can freeze hiring, delay product launches, and ultimately erode America's position as a global fintech powerhouse. There is, intriguingly, a third path. Congress could step in to write new laws, finally recognizing the unique characteristics of digital assets and providing a roadmap for compliance. Jeremy Allaire, CEO of Circle, puts it bluntly. A clear regulatory framework for stablecoins and digital assets is essential for the United States to remain a leader in fintech. The stakes here go far beyond Ripple or XRP. The outcome will influence how central bank digital currencies are designed, how stablecoins are regulated, and whether blockchain-based payment systems can truly compete with legacy networks like SWIFT. So, what does all this mean for everyday investors, developers, and technology watchers? First, it is a powerful reminder that in the world of digital assets, regulation is as important as code. The fate of XRP, and by extension many other digital assets, rests not only on technological innovation, but also on the words and decisions of lawmakers and judges. For investors considering a stake in crypto, it is crucial to pay close attention to signals from both the courts and Congress. The outcome of the Ripple SEC case could influence not just the price of XRP, but the trajectory of the entire digital asset market, including stablecoins and central bank digital currencies. For developers and entrepreneurs, the lesson is clear. Build for compliance from day one. Ripple's acquisition of Fortress Chain and its deepening partnerships with major banks show that regulatory readiness is not just a defensive move, it is a strategic advantage. As Brad Garlinghouse, Ripple's CEO, says, success will come to those who embrace both innovation and compliance. This philosophy has allowed Ripple to thrive even in the face of legal uncertainty, expanding its global footprint while many rivals struggle to keep pace. Let's not forget the broader context. Other crypto companies, such as Kik and Telegram, have faced similar allegations from the SEC, with mixed results. The absence of clear, consistent rules has forced many startups to operate in a gray area, constantly fearing the next enforcement action. This environment has led to a patchwork of legal strategies, with some firms choosing to settle, others fighting in court, and a few opting to exit the American market altogether. The Ripple case, with its high profile and far-reaching implications, has become the bellwether for an industry hungry for certainty. And here's an insider's secret. Behind the scenes, institutional giants are already positioning themselves for a post-Ripple SEC landscape. BlackRock, the world's most powerful asset manager, added XRP to its list of assets under consideration for a future exchange-traded fund earlier this year. This move, though quiet, is a signal that Wall Street is preparing for a world where digital assets are an accepted mainstream part of financial portfolios. If regulatory clarity emerges, expect a flood of new products, from crypto ETFs to blockchain-powered lending platforms, bringing digital assets to millions of new investors. Looking ahead, several scenarios could play out. If Ripple secures a favorable settlement or legislative breakthrough, we may witness an explosion of innovation. Banks integrating blockchain for instant settlements, central banks piloting digital currencies, and startups launching new financial products unimaginable under the old system. XRP's price could surge, and Ripple's model could become the blueprint for how to build a compliant global payments network. Conversely, if legal ambiguity persists, the United States risks falling behind in the race to define the future of money. Emerging markets in Africa, Asia, and Latin America, unburdened by regulatory gridlock, may leapfrog ahead, using blockchain to solve real-world problems long before American policymakers find consensus. But there are risks, too. Regulatory clarity in the United States could embolden other jurisdictions to take a tougher stance, especially if they see America as setting a restrictive precedent. Or, if the Ripple case ends in further stalemate, we could see a fragmented global market, with conflicting rules creating barriers to cross-border innovation. The outcome of the 2028 American elections may also play a pivotal role, depending on whether policymakers favor a pro-innovation or enforcement-heavy approach. In conclusion, the Ripple SEC case is more than just a headline or a courtroom drama. It is a turning point for global finance, a test of America's ability to adapt to technological change, and a case study in how law and innovation collide. Whether you are an investor, developer, or simply a curious observer, the story unfolding in this New York courtroom will influence how we move, manage, and imagine money in the years ahead. So, will Judge Torres provide the clarity the crypto world craves, or will this legal battle rage on? No one can say for certain, but the odds now seem to favor a resolution, at least according to leading legal voices like John Deaton. Still, even if the immediate case ends, the fight for comprehensive, sensible regulation has only just begun. Stay tuned, stay informed, and remember, regulatory clarity is not just a headline, it is the foundation for real innovation in how we move and manage money around the world. If you found this analysis valuable, don't forget to like, subscribe, and hit the notification bell for more in-depth stories on global economics and technology. And let us know in the comments, do you think the United States will finally get it right on crypto regulation?